Item 501.
My learned friend who was on his legs on last day says that he would take 4 minutes. I'll start after that.
Today you're saying something?
Yes, ma'am.
You're saying something, I missed.
Yes, ma'am. I'm sorry. Lord, I was to start,
Yes.
but my learned friend, my Lord, who was arguing on the last occasion, requested that he has few minutes to argue. I'll argue, my Lord, after he completes.
Sure.
Because there's one item 501.1 as well, Milots. I would like to address just for 5 minutes because that arises out of section 9, Milots, not under 11 and 8. 5.
Please, my lord, before he commences, Mr. Sibal had concluded his arguments on Thursday,
Yes.
seeking permission to file a note on arguments on his behalf.
Yes, yes, you can file that.
Great.
And you email a soft copy to the court master.
Yes.
Because I had submitted a note, I
You are in IA 58168.
my lords.
Yes, Ms. Plonge.
Because I've tried to deal the questions that have fallen for my lords in the last 2 dates. The first question that fell for my lords is how do you infer conduct under section 7? Where is the rule for conduct? My lords, in my humble submission is, my lords, that the provision of section 7 is pari materia to the New York Convention, Article 2.2. And generally, there's a handbook of judges, which International Council for Commercial Arbitration's guide to the interpretation of the New York Convention.
You have made some submissions? Have you circulated? I'm just asking.
Yes, Lord.
I've circulated a note, my lords.
What's under what?
Written submission. Pallav Mongia.
The hard copies also.
Yeah.
So there's a handbook for judges.
Yes.
My lords have it, my lords? Which contains a checklist setting out the questions to be answered and the steps to be followed by courts when applying the New York Convention. In relation to Article 2.2, it lays down the following. Is the arbitration agreement evidenced in writing? Examples is the...
Mr. Babu,
Sorry.
you are reading from where I'm not got it. It's your compilation on behalf of the intervener?
Yes. My lords, there's a compilation also. I've put the entire...
Written
Just,
submit. All right.
just to save time, I was reading from the note only which I've extracted. The relevant portion I've extracted.
Just a second.
He is Sanjay Ghosh. Written submission.
Yes, Lord.
IA 58166. Got it.
मिला आपको?
Mila.
It's in.
Correct.
This one.
Correct.
Yes.
My lords, it's the International Council for Commercial Arbitration's guide to the interpretation of the New York Convention, para 2 in my note, my lords, where they've laid down a checklist setting out questions to be answered and steps to be followed by courts when applying the New York Convention. In relation to Article 2.2, it lays down the following, and the provisions are pari materia, Section 7 and Article 2.2. Is the arbitration agreement evidenced in writing? Examples, is the arbitration agreement incorporated by reference? Has the arbitration agreement been tacitly accepted? Similar is the position in UK law also. My humble submission is that the concept is not restricted to signatories, but it's open to interpretation. And that conduct has to be inferred from anything which is evidenced in writing. That is the test. So it excludes oral agreements. Orally, one can't come to court and say, look, there was an arbitration agreement. But as long as there's something evidence in writing from where one can infer the conduct, that will fit into the description section 7 Milords.
UK law 5.
And UK law also, Milords, section 5 subsection 4, an agreement is evidence in writing. If an agreement made otherwise than in writing is recorded by one of the parties or by a third party with the authority of the parties to the agreement. So oral agreements are barred, but anything evidence in writing should be enough to infer the conduct of the parties.
Right.
And there are two instances where my lords have given liberal interpretation to the arbitration agreements. One is a Trimex judgment, which I've quoted here. Second is one Govind Rubber. It's of 2005. I'll just read the relevant parameters. It's very useful. Perusal of the aforementioned provisions would show that in order to constitute an arbitration agreement, it need not be signed by all the parties. Section 7.3 of the Act provides that the arbitration agreement shall be in writing, which is mandatory requirement. 7.4 states that the arbitration agreement shall be in writing if it is a document signed by all the parties. But the perusal of clauses B and C of section 7.4 would show that the written document which may not be signed by parties, even then it can be arbitration agreement. 7.4b provides that the arbitration agreement can be cut out from an exchange of letters, telex, telegrams, or other means of telecommunications which provide record of the agreement. So that's how the expression record of the agreement has been interpreted. It's akin to evidence in writing. That's my humble submission. And that's how the concept of implied consent is also borrowed. Para 6 I've reproduced from Gary Bond, Milords. The entire chapter is very interesting. I've reproduced the entire chapter in my compilation. Coming to section 8, Milords, interpretation of section 8. Because one of the main arguments that was made under section 8 was that there's no power vested in court under equity, and therefore equitable principles cannot apply. My response to the same is that these arguments come forth when the judicial fora or the courts are creation of that very statute. So they are bound by the powers given in that statute. But this is a case where courts are not creation of the statute or judicial authorities. They're already pre-existing under some provision. They have inherent powers. This act just gives an additional charge to those courts and say, look, you can exercise these powers also. For example, the arbitration tribunal's powers are restricted. And where they wanted arbitration tribunal not to apply principles of equity, they're mentioned so in section 28.2. I have not reproduced a provision, but 28.2 clearly states that arbitration tribunal will apply principles of equity only when the parties agree so. So no such exclusion is made in section 8, Milords. Thus, section 28.2 of the Arbitration Conciliation Act states that unless the parties expressly authorize the tribunal to decide ex equo et bono or as amiable compositor, the tribunal cannot decide on the principles of equity. Alternatively, Milords, my submission is that the application of principles like lifting of the corporate veil or third parties or looking at the intent is not a concept of power. It is a concept of application of legal principle.
Okay.
For example, the lifting of the corporate veil, it's not a power vested in any particular statute like Companies Act, etc. But courts, while interpreting various statutes, resolving disputes which come before them, they apply the principles of corporate veil. For example, the Constitution Bench judgment of LIC versus Escorts. I have reproduced in para 3, B3, Milords, page 4 of my submission. This is a case which pertained to FERA. And there was no express provision, unlike the taxation statutes, which specifically provide for lifting of the corporate veil. In FERA, there was no such provision. Yet, the court was called upon to lift the corporate veil and see who's the owner. Similarly, industrial disputes also. The tribunals specifically try to find out who's the employer. And for that, if they have to lift the corporate veil, they lift the corporate veil. If I may just read this para 90 from LIC versus Escorts. It was emphasized that regard must be had to the substance and not the form of a transaction. Generally and broadly speaking, we may say that the corporate veil may be lifted where a statute itself contemplates lifting the veil, like a taxation statute, or fraud, or improper conduct is intended to be prevented, or a taxing statute or a beneficent statute is sought to be evaded, or where associated companies are inextricably connected as to be, in reality, part of one concern. It is neither necessary nor desirable to enumerate the classes of cases where lifting the veil is permissible, since that must necessarily depend on the relevant statutory or other provisions, the object sought to be achieved, the impugned conduct, the involvement of the element of public interest, the effect of parties who may be affected, etc. So statutory power is not the test. The application of principle will happen if such situations were to arise before the court.
Thank you. Then now we'll read the rest of the.
Just one last submission, Milas. I'll just take 2 minutes. Milas, what I've also done is, Milas, I straight away have page 7 of my submission. I've put in a table where US courts have applied various principles to involve third parties in arbitrations. A submission was made previously, my lords, that US courts don't recognize group of companies doctrine. But that does not mean that they don't extend their jurisdiction to non-signatories. These are various instances where they have extended jurisdiction to non-signatories, my lords. One important is, my lords, CCL number 1, Alter Ego, Shapoorji Pallonji Company Private Limited versus Other India. There's a Delhi High Court judgment where they actually analyze the US law and says that, look, these principles are applicable in Indian jurisprudence as well. May I just direct my lord's attention to the compilation. Miles may have page 172 of my compilation. Miles may have straight away para 24 and 25 on page 178. Miles have it, please?
Yes.
He first quotes Gary Bond. According to Gary Bond, the principal legal basis for holding that the non-signatory be bound by an arbitration agreement is to include both purely consensual theories, example, agency, assumption, assignment, and non-consensual theories, example, estoppel, alter ego. In several cases, implied consent is used as a basis to hold that non-signatories are bound by the arbitration agreement. It is well settled that in cases where the signatory is an agent of the principal can be compelled to arbitrate, even though it is not a party to the agreement. This rests on the principle that the arbitration agreement may not have been signed by non-signatories, but was executed on its behalf. This principle is applied essentially in cases where agent-principal relationship is established between the signatory and the non-signatory, and it is established that the signatories had acted under authority of the principal. There are several cases where the courts have found the conduct of the signatory and its principal to be sufficient evidence of the relationship. And then they quote other instances where other principles apply. For example, the quotation para 26, where a party conducts itself as if it were a party to a commercial contract by playing a substantial role in negotiations and or performance of the contract, it must be held to have impliedly consented to be bound by the contract. And then they go on refer to other cases. Gary Bond is referred again, para 29. Para 31, there's an important quotation. The court observed to allow plaintiff to claim the benefit of a contract and simultaneously avoid its burdens would both disregard equity and contravene the purposes underlying enactment of the Arbitration Act. This is where the principle of equitable estoppel comes in. And in the next para 32, a non-signatory may be stopped from avoiding arbitration where it knowingly accepted the benefits of an agreement with an arbitration clause. The benefits must be direct, which is to say flowing directly from an agreement. And then they go on analyzing Dow Chemicals. I'm skipping all of that. I mean, the US Supreme Court judgment is very important, para 37, where again they apply principles of equity estoppel. And then they repeat all the MTNL cases and all. And they conclude that they need not rely upon group of companies doctrine to reach their conclusion. There are other principles which are actually taken out of principles of contract, agency, and corporate law principles and equity to reach the same conclusion. My concluding submission is, my lords, that my lords are deciding the scope of group of companies doctrine, but my lords may consider that non-signatories should not be completely ousted from because of the ruling on group of companies doctrine. There are other tools available in the statute which permit application of addition of non-signatories to that. I'm highly obliged.
Thank you, Ms. Mungia.